Welcome, everyone. Welcome to the June edition of the Wisconsin Bankers Association Compliance Corner. Scott and I are always happy to walk you through the items that we have noticed have been issued by various agencies since we last met. And so we have a list here for you for what's come down the pike, so to speak, from the agencies over the last several weeks. And as usual, you will have a listing on our next slide of all the topics that we're going to be talking about. And each of these items, there will be an accompanying link below the video where you can pull the actual item to look at it more closely or to get it over to the right person at your organization that might be the subject matter expert of that particular topic. So this particular month, we kind of broke it up differently than we have in the past, where we have done a slide on final rules, of which there are two items that we'll be talking about: an interagency final rule about AVMs, and also the first of two rules regarding Section 1033 from the Bureau. And then we'll talk about proposed rules or an information collection, something related to AI, and I think more importantly, a prohibition of medical information in consumer reports that we'll talk about briefly. And then we have a whole host of a bit of a mismatch of other releases, some final in nature, some guidance, other items, just a summary of information that's been collected by an agency, but all important information to be aware of that we'll be going through each one by one. So let's go ahead and start off with the final rules. And as I mentioned, there are two final rules that Scott and I wanted to make sure that you were aware of. The first being an interagency final rule, and we have listed for you all of the different agencies that were part of this rule. And this item actually comes from a Dodd-Frank Act. So hard to believe that all these years after Dodd-Frank, we're still implementing rules, but such is the case. The Dodd-Frank Act revised FIREA, which that's the area of law that deals with protection of collateral and appraisals and valuations. And here we have a final rule that is meant to create quality control standards for a bank or secondary market that is using an automated valuation model, or an AVM. And the hope is that by having this rule, it'll provide some clarity, it'll provide some conflict of interest rules, protect against any kind of manipulation of data, really trying to take some worry out of how embedded coding or other types of trends could be made within an automatic valuation model. Important to note that the rule is narrow in scope in that it applies to loan transactions where the collateral is a mortgage secured as the consumer's principal dwelling. So it isn't with every single loan that we make, but a good portion of the loan. It's a rule that just was released, has not yet been published in the Federal Register as of time of our conversation. So we'll have about a year to implement this going forward. So stay tuned for more, but that rule is out. Another rule that is out is a CFPB rule. This is also a Dodd-Frank Act requirement. If you think about data, there are rules that require us as financial institutions to protect the data from disclosure to others. And there is a rule that allows for data to be portable, that a consumer owns their data and is able to take and transport that data with them someplace else. So the first step in that data transportation type of theory is to set standards of what kind of computer systems or what kind of program or what can companies create that will then be the aggregators of this personal data. And they're really wanting to make sure that these computer programs are open, they're transparent, again, that there's no manipulation of data, and that everyone is sharing what those sources will be, so that then there's a fair playing field in that one particular company is going to own all of those neat tricks and computer programs. There will be a process for these computer companies to file with the CFPB to be recognized as an company that has met the standards that have been set by the CFPB. That's part of the rule So it's really just the data piece, the starting of the creation of the computer programs that we're starting with. There will be a separate rule yet with what data can be transported or made available to consumers. So stay tuned for that. But we have the first one here on that stepping stone of what needs to be implemented underneath Section 1033 of the Dodd-Frank Act. So those are the final rules. Let's now pivot and talk about proposed rule and an information collection piece. Scott, you want to walk through that?
Yeah, sure thing. So now on to those rules that are in the proposal stage. First, we have Treasury proposal, or rather an RFI on the risk of artificial intelligence use. And so artificial intelligence is going to continue to be a topic, right? It is a topic, but I think as it continues to develop and we continue to see how it's used, the implications of its use, and the regulators continue to look at it as well, what their expectations are going to be, and again, where the landscape develops here. So that's what this really gets at. And the Treasury has issued this, again, it's a RFI, it is a request for information. And specifically, Treasury is asking for any information on the use, opportunities for how AI can be used, risk that might be presented by development and applications of artificial intelligence, all within the financial services industry. And so Treasury has been working on a larger report on managing AI cybersecurity risks, and this RFI is a part of that process. And they purely and truly are looking for information at this point, at this stage. And as part of this report that Treasury is working on, they've had interviews, and those interviews have been specific. And so there's been specific questions for a smaller pool of interviewees and specific information they're looking for. But with this RFI, Treasury's goal is to hit a broader range of financial institutions. And so specifically, they're not looking for a particular category. They're looking from everything, from large and small, from those with bigger or smaller scopes, from those with more or less infrastructure, all levels of supporting and developing AI tools. And so kind of a component to call out within that is, as we've seen, a big part of AI and will continue to be with AI is third parties, right? And looking at third parties that are providing AI solutions, how the third parties are facilitating this AI, how it's being deployed, what it's being used for, what that oversight is, what data it's using, what it's using that data for, a whole host of questions. And we can anticipate expectations surrounding that as well. So any experiences that you have from a perspective or internally, depending on what you might be developing or utilizing AI for, that could be valuable to Treasury. And again, truly, that's what they're looking for. So if that is a perspective that you have to share or any information to provide on that regard, Treasury is looking for comments by August 12th of this year. Next item we have, as Heather mentioned, is this is a significant proposal to look at here from CFPB. And what CFPB has proposed here is a rule that would shift the way we look at considering medical debt for purposes of credit reports. In this case, it would prohibit lenders from considering medical debt, and it would remove medical bills from most credit reports. So since this is a bit of a shift of what we've seen, to talk about what CFPB is trying to do here, the goal is to increase privacy protections and increase credit scores and loan approvals, and overall prevent debt collectors from using the credit report to essentially coerce people to pay. And so along with this, we're anticipating some additional proposals from CFPB. This is specific to this medical debt and specific to this issue, but kind of hand in hand with this is we would anticipate CFPB issuing additional proposals related to implementing other credit report changes that we've seen CFPB discussing over the past year. But this rule specifically would prohibit credit reporting agencies from sharing information about medical debts with lenders, and it would prohibit lenders from making lending decisions based on medical information. And so medical debt information is a term within this proposal and would generally only cover debt that the consumer owes directly to a healthcare provider, but that would include such debt that has been sold on the secondary market. So as a result, the rule wouldn't prohibit use or reporting of information about debts for medical care that's charged to credit cards, for example, including medical credit cards that might be offered specifically for the payment of medical services. But again, that scope is worth considering within the proposal. And kind of the context here is that currently we have restrictions from obtaining or using medical information through the Fair and Accurate Credit Transactions Act, but the regulators have a policy exception for using medical debts in certain credit decisions that we see in those FACTA disclosures and how it's used currently. So again, the long story short here is that this proposal would effectively reverse that current regulatory policy. So certainly something we need to watch and see as this develops, along with what CFPB is also contemplating in terms of the credit reports. Moving on, as Heather said, we have a host of other releases that we want to go through here now on the next two slides. So the first section of other releases to cover is a IRS notice. And for this, we just wanted to make you aware that IRS has published this notice, which includes quite extensive guidance on application of two specific exceptions to the 10% tax penalty. And these exceptions are for emergency personal expenses and domestic abuse victim distributions. And these are when the distributions are made from certain retirement investment plans, such as an IRA, for example. Generally speaking, where this arises is that the Internal Revenue Code does place a 10% additional tax on distributions that are made from qualified retirement plans, unless an exception applies. Now, notice provides definition of what a qualified retirement plan is, and it does have references to the Internal Revenue Code for further reference if you're looking to build or develop on that. It discusses these two exceptions primarily, is the focus of it. So have those references, but at length, it gets into these two specific exceptions from that section of the Internal Revenue Code. That includes when they apply, conditions for approval, maybe there's certain conditions within the exception for it to apply or when it might not apply. There's also questions and answers for each one, as well as examples. So again, this is more something to be aware of, given there might be a situation where your customers might qualify for an exception or are looking to use an exception or maybe have questions or have heard or are aware of it. It's of course not something that banks are expected to provide tax advice to their customers on or directly answer those questions. That's not going to be the role. It's going to be the role of their accountant or their tax advisor, as we know. But we wanted to mention it as it's worth keeping in your back pocket. It's something to be aware of should it arise. The next item we have are some FinCEN releases. And as in the past, we like to include these FinCEN advisories in order to stay on top of financial crimes and trends, right? Know the red flags, SAR expectations, and general due diligence requirements. No difference with this FinCEN release. This advisory, similarly laid out to those others and those that we're familiar with. This particular advisory covers new trends in the illicit fentanyl supply chain, particularly in relation to chemicals and equipment that's used in production of the drug. And so this advisory urges vigilance in identifying and reporting suspicious activity that's associated with the distribution and the manufacture of fentanyl, specifically with regard to Mexico-based transnational criminal organizations and how they're getting the fentanyl precursor chemicals, and then the manufacturing equipment as well, which is coming from China-based suppliers. So take a look at that. Again, more information, the red flags, due diligence conditions, and how to stay on top of this, how to remain vigilant in identifying information that can help FinCEN track down this illicit activity, this illicit drug activity. We also have the beneficial ownership information FAQs in here. As we've reported on the past, FinCEN continues to update this FAQs. We have new FAQs here as well, those which have been added and others that have been updated. Again, those are in the link to the description below on FinCEN's website. And lastly, wanted to mention that FinCEN has released its 2023 year in review. We wanted to put this in there for those who might be interested in the reports and findings of FinCEN, which has been aggregated through the last year. such as SARs, CTRs, information sharing statistics, financial literacy, among other items. So, for example, how many have been filed, topics that are involved. It's all presented in the form of infographics. So it's not a huge, long, lengthy read report. It's very easy to page through and digest. So take a look at that within the link in the description below as well. And for the final other releases, I will hand it off to Heather.
Super. Thank you, Scott. So a couple other items that we wanted to make sure that you were aware of. First being that the CFPB issued an article, published it actually in the Federal Register, and there's a link to that below, about a caution of unfair or unlawful, I should say, and unenforceable contract terms. And this was really just to put out there a caution to make sure that you're aware of what are in your boilerplate types of language in different types of agreements that are affecting consumers in a negative way. And through the examples portion of that piece, they've kind of focused in on terms where a customer is agreeing to waive rights that the customer otherwise is afforded to underneath law. So an example of that would be they found in auto loan programs, the terms of the auto loan program had consumers waiving their rights to certain bankruptcy rights, which those are rights afforded underneath bankruptcy law that the consumer is afforded. Remittance transfer transactions where consumers were waiving rights that they had for error resolutions. Also in bank deposit account agreements, there were times when they found language where the consumer was waiving the rights that they hold when a bank improperly responds to a garnishment order, the Treasury rule. Those are rights that the consumer has underneath that particular area of law and should not be something that is waived. So just some cautionary tales in your contracts to make sure that there isn't something embedded that is a waiver of rights that the consumer would otherwise have underneath a particular area of law that's applicable to the transactions at hand. Just a caution on that. We also wanted to make sure that you had the information about OCC's semi-annual risk perspective. We have reported on FDIC's and on the Federal Reserve's risk perspectives in previous videos, and here's the OCC's. You'll find some similarities to what the other regulators have identified as being risks, both from a credit risk standpoint, an operational risk standpoint. I know Scott and I have talked about third-party risks before. So you'll want to take a look at that particular report if you are an OCC-regulated financial institution, because OCC then will pick up on those risks in their examinations. They're going to focus in on what those risks are to make sure that banks are protecting themselves as best they can as applicable to the business model of each bank. We also wanted to make sure that you're aware of a new pilot program that's being offered by Freddie Mac. For those of you that work with Freddie Mac in your lending programs, that they now will be having a second mortgage option where for a finite period of time underneath this pilot program, up to a little bit over $2 billion in a portfolio, Freddie Mac is willing to purchase closed-end second mortgages. There are terms for the program, meaning that the length of time and the dollar amount of those second mortgages, closed-end mortgages, but it's a new opportunity that Freddie Mac will be offering. And they'll monitor that and then report back as to whether or not that'll be a permanent program or just temporary underneath their current procedures. We wanted to make sure that you're also aware of updates that FDIC has made to their compliance exam manual. And so we've provided you a link to that latest manual. And when you scroll through the table of contents, you'll see June dates for what sections have been updated, which is always good to know, because again, that helps with the focus of what your examiner team is going to be looking at. And then lastly, we wanted to make sure that you were aware of resources from FDIC on their final rule that changed their official signage for advertisements and change some rules relating to misrepresentations of entity being FDIC insured, or just misuses of FDIC's name or logo in general. As you may recall, there's a new rule out there effective here this year, and FDIC has had webinars about the rule. We've actually also here at the office been collecting questions on behalf of our members about that rule and submitting those to FDIC on behalf of the membership, because we've got some unanswered questions, unfortunately, quite yet on that rule. There's some ambiguity in the language and what is expected of FDIC. So feel free to send those questions our way. But FDIC has been also trying to get the word out about that final rule through webinars. And they have had one already. And this link that we have provided you to is actually to the slide presentation of that first webinar program. But also keep that webinar or keep that series in the back of your head, because there's 3 more to be had through that series. Not yet been scheduled, so keep your eye on the page that we've linked you to for those announcements. Those programs are offered through Teams and is a good way to digest that rule even further. And I would anticipate more FAQs will be issued and released to the industry about the rule forthcoming here in the next couple months. So with that, that's our list of resources from an agency standpoint. But Scott, you want to take us through with what we offer here at the WBA for our members, please?
Yeah, as always, we just like to mention, in addition to these videos, all the other resources that are available to you as a WBA member and ways to get involved. For example, joining a WBA section or committee, becoming an advocate for the banking industry through advocacy officer opportunities, and ways to get involved through both of those opportunities. But also the compliance hotline that we have available. As Heather said, if you have questions on FDIC advertising or any other matters, for that matter, you can send them in my email or just give us a call. We're happy to talk them through, as well as WBA legal in-house compliance training. So if you want myself and Heather to conduct some training on a particular topic or an area, be it a new area or something new, got some new staff for training, or just looking for a refresher, that's something we're happy to set up with you and work with you on. Also wanted to mention the WBA website. Of course, there's compliance tools and resources, publication, training, can find these videos on there as well as the best practices library. And so the best practices library has a whole host of resources on it. There's a compliance section as well, which you'll find that we've recently updated with some new resources. And specifically, we're creating a banker's guide series. And so you'll find a guide related to topics such as the Marital Property Act, the Wisconsin Consumer Act, transfer by affidavit. So take a look at those guides as they delve into a more comprehensive look at various areas. We also have a new legal question and answer. And so this takes the most frequently asked questions from our call program and puts them into a more comprehensive Q&A. So if you want to see some of the frequently asked questions, certainly I think there are some topics, as those are selected, to kind of be helpful starting points for common questions and common situations that bankers find themselves in. So certainly take a look through there, see if it might have some answers or some areas that might be worth taking a look at. The best practices library is, of course, behind a password. So if you need that password, reach out to the legal call program, and we'd be happy to be able to get that over for you so you can get access to the best practices library. Thanks, everyone, and we will see you next time.